Rule 85, Accountability and Compensation of Executors and Administrators. Section 1, Executor or Administrator chargeable with all estate and income. Except as otherwise expressly provided in the following sections, every executor or administrator is chargeable in his account with the whole of the estate of the deceased, which has come into his possession at the value of the appraisement contained in the inventory, with all the interest, profit, and income of such estate, and with the proceeds of so much of the estate as is sold by him at the price at which it was sold. Rule 85, Section 2, not to profit by increase or lose by decrease in value. No executor or administrator shall profit by the increase or suffer loss by the decrease or destruction without his fault of any part of the estate. He must account for the excess when he sells any part of the estate for more than the appraisement. And if any is sold for less than the appraisement, he is not responsible for the loss if the sale has been justly made. If he settles any claim against the estate for less than its nominal value, he is entitled to charge in his account only the amount he actually paid on the settlement. Rule 85, Section 3, when not accountable for debts due estate. No executor or administrator shall be accountable for debts due the deceased which remain uncollected without his fault. Rule 85, Section 4, accountable for income from realty used by him. If the executor or administrator uses or occupies any part of the real estate himself, he shall account for it as may be agreed upon between him and the parties interested, or adjusted by the court with their assent. And if the parties do not agree upon the sum to be allowed, the same may be ascertained by the court, whose determination in this respect shall be final. Rule 85, Section 5, accountable if he neglects or delays to raise or pay money. When an executor or administrator neglects or unreasonably delays to raise money by collecting the debts or selling the real or personal estate of the deceased, or neglects to pay over the money he has in his hands, and the value of the estate is thereby lessened, or unnecessary cost or interest accrues, or the persons interested suffer loss, the same shall be deemed waste, and the damage sustained may be charged and allowed against him in his account, and he shall be liable therefore on his bond. Rule 85, Section 6, when allowed money paid as costs. The amount paid by an executor or administrator for costs awarded against him shall be allowed in his administration account, unless it appears that the action or proceeding in which the costs were taxed was prosecuted or resisted without just cause and not in good faith. Rule 85, Section 7, what expenses and fees allowed executor or administrator not to charge for services as attorney, compensation provided by will controls unless renounced. An executor or administrator shall be allowed the necessary expenses in the care, management, and settlement of the estate, and for his services 4 pesos per day for the time actually and necessarily employed, or a commission upon the value of so much of the estate as comes into his possession and is finally disposed of by him in the payment of debts, expenses, legacies, or distributive shares, or by delivery to heirs or devices of 2 per centum of the first 5,000 pesos of such value, 1 per centum of so much of such value as exceeds 5,000 pesos, and does not exceed 30,000 pesos. 1/2 per centum of so much of such value as exceeds 30,000 pesos and does not exceed 100,000 pesos, and 1/4 per centum of so much of such value as exceeds 100,000 pesos. But in any special case where the estate is large and the settlement has been attended with great difficulty and has required a high degree of capacity on the part of the executor or administrator, a greater sum may be allowed. If objection to the fees allowed to be taken, the allowance may be re-examined on appeal. If there are 2 or more executors or administrators, the compensation shall be apportioned among them by the court according to the services actually rendered by them respectively. When the executor or administrator is an attorney, he shall not charge against the estate any professional fees for legal services rendered by him. When the deceased by will makes some other provision for the compensation of his executor, that provision shall be a full satisfaction for his services, unless by a written instrument filed in the court he renounces all claim to the compensation provided by the will. Rule 85, Section 8. When executor or administrator to render account. Every executor or administrator shall render an account of his administration within 1 year from the time of receiving letters testamentary or of administration, unless the court otherwise directs because of extensions of time for presenting claims against or paying the debts of the estate or for disposing of the estate. And he shall render such further accounts as the court may require until the estate is wholly settled. Rule 85, Section 9. Examination on oath with respect to account. The court may examine the executor or administrator upon oath with respect to every matter relating to any account rendered by him, and shall so examine him as to the correctness of his account before the same is allowed, except when no objection is made to the allowance of the account and its correctness is satisfactorily established by competent proof. The heirs, legatees, distributees, and creditors of the estate shall have the same privilege as the executor or administrator of being examined on oath on any matter relating to an administration account. Rule 85, Section 10. Account to be settled on notice. Before the account of an executor or administrator is allowed, notice shall be given to persons interested of the time and place of examining and allowing the same, and such notice may be given personally to such persons interested or by advertisement in a newspaper or newspapers or both, as the court directs. Rule 85, Section 11. Surety on bond may be party to accounting. Upon the settlement of the account of an executor or administrator, a person liable as surety in respect to such account may, upon application, be admitted as party to such accounting.